global happenings today. We communicate, we analyze global news. Stay tuned.
Hello, beautiful people. Welcome to Global Happiness today. This is a bit of a setback, but then again, the legal team of Nnamdi Kanu have decided to take another move. As we speak, courts have revoked and declined Nnamdi Kanu's request. In a moment, you're going to find out exactly why they did what they did, and the excuses they gave, and the defense counsel what they gave. Before we go into the news, I'd like you to subscribe to our channel by clicking on the red subscribe button. Beside it, you see a bell notification icon. Please go ahead, click on it to get notified as soon as we update our channel on YouTube. Well, a federal high court Abuja on Wednesday dismissed a motion filed by the leader of the indigenous people of Biafra, Nnamdi Kanu, for the Director General of the Department of State Services to give oral evidence on his state of health. Justice Taiwo in the ruling held that fundamental right cases are special cases sui generis, which mode of commencement is affidavit evidence as prescribed under Order 2, Rule 2 of the Fundamental Human Rights Enforcement Procedure Rules 2009. Justice Taiwo said that though there were various modes of commencement of action, including fundamental rights cases, which Kanu applicant chose to commence his under the Fundamental Right Enforcement Procedure Rules that stipulate affidavit evidence. He ruled that after carefully perusing all the affidavits of the applicant and the respondents before him, he was of the view that there was no irreconcilable conflict in the affidavits. The judge therefore declined to grant Kanu's application and was accordingly dismissed. Taiwo adjourned the matter until April 13 for the hearing of the substantive application. The news agency also added that Justice Taiwo had on March 7 fixed today for the ruling on Kanu's motion filed by his lawyer Maxwell Opara. Opara in the application prayed the court to direct the DSS DG and the indigenous people of Biafra leader to appear before the court to give oral evidence regarding the health condition of the latter, that's of Nnamdi Kanu himself. Report has it that Kanu, through his lawyer, had in a fundamental right enforcement suit marked FHC/ABJ/CS/1585/2021 sued the DG of the DSS, that's the DSS, the Directorate of State Services, Secret Service, an arm of our security agency in Nigeria, and the office as first and second responded respectively. He also joined the Attorney General of the Federation, AGF, as third respondent in the suit dated and filed in December 13, 2021. Opara had alleged that the health of his client was deteriorating in the DSS custody. Among others, Opara had filed a motion on notice dated February 14 and brought pursuant to Section 116 of the Evidence Act. He argued in the last adjourned date that there were conflicts in the counter affidavit filed by the DSS and that only oral evidence of the DG and Kanu could clarify the issue. We want to call Kanu and Director General of DSS to testify, he said, but the DSS, through its counsel, Idowu Awo, disagreed with Opara. He argued that while the judge had powers to call oral evidence of parties, Kanu's lawyer had not shown how the doctors attending to his client were doing quack work. He further argued that merely stating that the medical doctors his office assigned to attend to Kanu were quack did not amount to conflict. It is important to note that the applicant has not denied the above assertion by the respondent, neither has he shown by material particulars that the listed medical practitioners are quacks. The onus lies on the applicant via further affidavit, he said. He prayed the court to discountenance the application. I quote him, he said, "We humbly argue that the application be thrown away and let us go into substance of the case, he said. Also, in the counter affidavit dated February 24, I will argue that it was common knowledge that Kanu was currently standing trial on a 15-count charge bordering on terrorism before a sister court. He also argued that it was common knowledge that Kanu was earlier granted bail by the trial court presided over by Bita Nyako, but he jumped bail. He said he was rearrested and rearranged before the judge. Awo said that there was no court order in existence anywhere, which is to the effect that applicant, Nnamdi Kanu, should have unrestricted access to his personal physician while in the facility of the first and second respondent. If there is such order, the applicant has the option to produce same in the further affidavit. He said that refusal to grant this application would not prejudice Kanu's case in any way. The AGF's lawyer, that's Simon Enoch, also corroborated Awo's submission. He said there was no material conflict in the affidavit of facts submitted before the court. He also prayed the court to reject Opara's plea. Don't forget that Opara is Mazi Nnamdi Kanu's lawyer, also representing Mazi Nnamdi Kanu in this case. And now, he's actually suing, for just a quick recap, he's suing AGF, Malami, and DSS. That's the DSS for over his health status. And they wanted the DSS DG and Mazi Nnamdi Kanu to answer, to do oral interview in the court where they can cross-examine them. Obviously, the other councils rejected it, and of course, the judge also applied as in agreed to their rejection. Well, a lot of people have been reacting. We're going to take just like two, and we'll go straight into the analysis very quickly. This one is a waiting do himself. I being want to run away again. Make na WhatsApp well. Okay, make on a watch well. This one is beginning of season film. Which one is season film again? It's a court case. It could go either way. But whatever the case is, it clearly shows that Mazi Nnamdi Kanu's lawyers are not sleeping. Or, of course, they are insisting that other issues should be addressed. Be that as it may, it's just a little step back. And it is not a case that it has been rejected, but rather is a case of saying that the material evidence they brought it's okay, it's not conflicting, that the doctors they are giving to Mazi Nnamdi Kanu is not quack, that the Department of State Services, that's the DSS, that's the full meaning of DSS, Department of State Services in Nigeria, is giving him the right doctors, and there's no special affidavit or rule that says he should get his own personal lawyer, personal doctors, but the doctors given to him by both AGF and DSS and the federal government is just good enough. And the Mazi Nnamdi Kanu's lawyer Opara is insisting that both of them should be allowed to give oral evidence in front of the court, of which, well, the judge himself had, cancelled that. They should move on to the main substance. That's what we're going to wrap it up.